My name is Barbara Shears-Walker. I will be reviewing case number DP-19-059. This case involves a 13-year-old boy who at the age of 5 in 2011 was first diagnosed with an autism spectrum disorder, and he was also diagnosed as having attention deficit hyperactivity disorder, oppositional defiant disorder, and mood disorder. In 2018, the 13-year-old boy was later diagnosed as having autism spectrum disorder, ADHD combined type, and oppositional defiant disorder. At that time of the referral, the student was receiving services in the CSEP ASD program under the category of autism with OT and speech and language as related services. Upon transferring to public school, the student began receiving related services at CSEP Re-Ed. The mother was considering a possible residential placement because she had recently given birth to a third child and wanted to ensure that the student could be sufficiently supervised. At that point, the maternal grandmother took the student into her home and, in agreement with the mother, initiated proceedings to obtain custody. The due process was initiated by the grandparent and by counsel requested an administrative due process hearing in her special education due process hearing request dated April 5th, 2019 under the IDEA Improvement Act of 2004. The grandparent was represented by attorney Kevin Ryan Mueller, Esquire. At the time this due process proceedings was filed, the boy temporarily resided in a group home while his maternal grandmother or guardian was convalescing following multiple hospital stays. The student has a long history of disruptive behaviors in the classroom that included verbal threats of staff and students, bullying, swearing, elopement, and aggressions. Other behaviors have included making sexual comments and gestures in front of staff and peers and exposing himself to staff and peers. These behaviors have significantly and increasingly interfered with the student's education during his enrollment in public school. Due to an increase in emotional and behavioral difficulties, the student was referred for a reevaluation by the public school to consider whether he met the criteria for services under another eligibility classification, namely ED. This due process complaint arose out of a disagreement between the public school and the grandmother as to which private day school should be selected as the appropriate private day placement location for the student for the school year 2017-2018. The issues and disputes of the case that focused on Fape were the grandparents' denial of a Fape claim based upon alleged deficiencies within the private day school the school administration selected has no foundation in IDEA, its implementing regulations, or case law regarding educational placement under the IDEA. The grandparent did not disagree with any aspect of the proposed IEP, including the LRE, or the least restrictive environment decision, that a private day school was the appropriate educational placement for the student. The grandparent disagreed with the private day school that the school administration selected. However, as previously stated, the school administration has authority to select the location where the student will be assigned to receive special education services under the proposed IEP. This denial of a Fape claim is based upon alleged deficiencies with the assigned location where the proposed IEP would be implemented. The hearing officer specifically finds that there was ample evidence before the school board to support the school board's decision to classify ED as the primary disability category. The hearing officer has found no denial of Fape by the school board, but the grandparent also failed to choose private educational services that conferred educational benefit on the student. Accordingly, the hearing officer finds that the private placement for the student is inappropriate. The hearing officer decides that the school board offered the student a Fape in the June 23rd, 2017 IEP, and that was inappropriate for the student. The strengths of the division's action is the due process, where the IEP addressed each of the disability-based needs of the student, including those rooted in his autism. The educators acted in a professional, collaborative, balanced, and expert way in designing for the student that individualized IEP, which is reasonably calculated to enable the student to make progress in view of the student's unique circumstances. The student's present levels of academic and functional performance of the proposed IEP contained all necessary information about the student to accurately identify his disability-based needs. The information in the student's present levels of academic and functional performance served as the basis for developing the other parts of the proposed IEP. Professional educators in the school division, who are the ones most familiar with the student, the child study process, the special education eligibility process, and the educational programming available within the school division, have testified regarding the appropriateness of the educational decisions rendering regarding the student. And the school board's witnesses who testified regarding the student have substantial training, expertise, and experience in working with children, both with and without disabilities, in educational programming in the Virginia public school setting with the student. The weaknesses of the division's actions in this due process were the IEP team again proposed home-based instruction until a longer-term private day placement could be secured. But on June 23, 2017, the IEP team met again to discuss the student's placement, and the June 23, 17 draft IEP did not propose a specific private day placement. Lessons learned that LEAs should take away from this case are: in a special education administrative due process proceeding initiated by the parents, the burden of proof is on the parents to establish by a preponderance of the evidence that the LEA has failed to provide the student with Fape concerning the issues they have raised. If the parent or parents of a child with a disability who previously received special education and related services under the authority of a local school division enrolls the child in a private preschool, elementary, middle, or secondary school without the consent of or referral by the local school division, a court or a special education hearing officer may require the local school division to reimburse the parent or parents for the cost of that enrollment if the court or the special education hearing officer finds that the local school division had not made a free, appropriate public education available to the child in a timely manner prior to that enrollment, and that the private placement is appropriate. A parental placement may be found to be appropriate by a special education hearing officer or a court, even if it does not meet the standards of the Virginia Department of Education that apply to education provided by the Virginia Department of Education and provided by the local school division.